Hi, it's Elgin of the Elgin and Walker team, and I'm here at Elgin Walker Real Estate Cafe, and I wanted to just give you guys something that I think is really important. Had a customer contact me, and unfortunately the gentleman was given some, in my opinion, bad advice. Had a piece of property, and he was told that he would be better off walking away from the property and allowing it to foreclose, which is what he did. Well, he was summoned and sued now by the bank that foreclosed on him. And of course, he wanted to know why. Is it legal? How is it possible? So before referring him to some attorneys to give him some specific advice on his specific situation, I wanted to talk to you and tell you guys this, which I feel is very important. Depending upon the circumstances, if you walk away from your home in foreclosure, the banks do have the right to still come after you for any deficiencies, and they do have the right to sue you, for what you owed in certain circumstances. So let me explain to you how and why. First of all, here in California, we are in a trust deed state. So what does that mean? Without getting into all the details, what it means is this, is that in most cases, you purchase real estate in a conventional manner, meaning you put some money down and you finance the rest. We call that a purchase money loan, purchase money transaction. You put some money down, you financed it, and now you're paying your mortgage 30 years, 15 years, whatever it is. Well, in California, if that particular financing is intact and you've never changed it, you've never refinanced or anything like that, and you unfortunately were to lose your home in foreclosure, almost like repoing a car at that point, the bank gets the property back. As far as them coming back to you to sue you for monies and that they cannot do. Now there are tax implications, but that's not what we're discussing here. Here's what a lot of us have done in California, and here's where you need to be careful. If you've ever refinanced a piece of property, taken money out, did an equity line, whatever the case may be, you no longer have your exact rate and terms intact from when you did your purchase money loan. You are now in what is called a non-purchase money transaction. And what does that mean? Again, in a nutshell, it means that you no longer fall under the guidelines of the state real estate laws as far as what happens to your property in foreclosure. Now, what we are going to see and are seeing already is this. If you unfortunately, say you pull money out of your house, you bought a Hummer, you bought a boat, you just did some home improvements, you just needed the money, whatever the case, you changed your original rate and term, and now you unfortunately lose your home in foreclosure, that does not necessarily mean that it's over. Particularly with the second trust deeds, the seconds that you've had, equity lines, seconds, whatever the case. Why? Because when that property goes to foreclosure, the second gets nothing. They're wiped clean. They now have no collateral with the property, and they just completely lose out. Well, guess what? There is a statute of limitations on that second being able to come after you, because you're in a non-purchase money situation. So you are going to see much more in the future where these seconds in particular, 50,000, 100,000, 200,000, they're going to come after you. They're going to sue you. They're going to get judgments against you. They have the ability to garnish wages. They have the ability to use a lot of things within their law, within their realm of the law in California to get some restitution. What they're also doing is this, which is even more ruthless for the consumer, is some of the banks on their seconds are selling the seconds to collection agencies, 10, 15 cents on the dollar. Now that collection agency comes after you, just like they would with a credit card or a student loan or anything like that. So unfortunately, when you walk away from a piece of property or lose the home in foreclosure, that does not necessarily mean that the nightmare is over. Depends upon the circumstances. These are some of the reasons that I am advocating you look at all of your options before you just walk away from something. This is why, if a short sale can be accomplished amongst numerous other reasons why, it is a much, much better option if you are unable to do a loan modification or whatever and keep your home. I would please advise anyone out there, particularly if you have ever refinanced, ever, equity lines, things like that, before you walk away, talk to a professional. Get some advice. Learn your options, because again, it may be a couple of years down the road, but they do have the right to come back. And I am predicting, unfortunately, many of them will. As always, in closing, please remember that no matter what you are going through in life right now, it is just a temporary condition, and it truly is a great life. May God bless, and you can always reach us at the Elgin and Pilar Walker team.com. Thank you. Have a blessed day.